Gaurav, the founder and visionary behind Law Jurist, to speak a few words.
Yeah, thank you so much, Dwarka, for such a warm welcome. I hope I'm audible to you all. Yeah. Okay. So talking about Law Jurist, as Dwarka rightly mentioned, Law Jurist is a registered and ISO certified organization. Our aim is to bridge the gap between law student legal profession, and to fulfill our aim and objective, we are once again back with this wonderful webinar on IBC. I would also like to thank Advocate Arpan sir for taking out time from his busy schedule and coming up this wonderful session. I hope the session will be very fruitful for you all, and you guys have a lot of takeaway from this sessions. And please, last but not least, please maintain the decorum throughout the session. Thank you.
Thank you, Mr. Gaurav. About today's webinar, the Insolvency and Bankruptcy Code has fundamentally transformed India's insolvency landscape. However, with evolving judicial interpretations, procedural challenges, and policy considerations, it becomes essential to examine where the IBC stands today and where it is headed next. Today's session has been curated to provide participants with practical perspectives, litigation insights, and strategic understanding of the future course of IBC from a practitioner's viewpoint. It is now my honor to introduce our distinguished speaker for the evening. We are privileged to host Advocate Arpan Behl, partner, Litigation and Dispute Resolution Practice at Economic Laws Practice, New Delhi. Advocate Arpan sir has over 10 years of extensive experience in handling complex commercial litigation, arbitration, and insolvency matters. He regularly appears before the Delhi High Court, various district courts, NCLT and NCLAT, and has represented clients in both domestic and international arbitrations, including ICC arbitrations, independently as well as co counsel. His practice spans key areas such as the Insolvency and Bankruptcy Code, commercial and contractual disputes, winding up proceedings, civil recovery, bank guarantee encashment, Electricity Act matters, check dishonor cases, and issues relating to criminal liability of independent directors, giving him a comprehensive and well rounded litigation perspective. Advocate Behl has been recommended for litigation by RSG and the Legal 500 Asia Pacific and is recognized as a future star for international arbitration by Benchmark Litigation Asia Pacific. He holds an LLB from IP University Delhi and is an associate member of the Chartered Institute of Arbitrators and has completed a certificate in insolvency and bankruptcy laws and procedure from the Indian Institute of Corporate Affairs. I now request all participants to actively engage with the session, note key takeaways, and post their questions in the chat box. A Q&A session will be conducted towards the end of the webinar. It's mandatory to fill the feedback form to mark your attendance and receive participation certificate. And the certificate will be shared too in the later part of the session. And please maintain the decorum of the session. Now, without taking much of the time, I invite our esteemed speaker, Advocate Arpan Behl, to share his insights on the evolving insolvency regime and guide us through IBC the way forward. Sir, the screen is yours.
Thank you so much for the introduction. I would not keep everyone waiting. I know it's Friday. So the idea of the presentation is this, that why the IBC came into the picture, what are the challenges which are being faced by IBC right now, and why the legislature felt that there is need for amendment in 2025. I assume that most of my audience is students, so I have kept it that way. My idea would be that A, so that you know what are the practical challenges we face day in, day out. Theoretically, you can also open any book and you will find that knowledge. But my idea would be to at least share my experience. Hopefully, you will gain something from it. So, my screen visible for the slide is visible to everyone, right? Hello, my slide is visible for everyone.
Yes, sir. It's visible.
Yes,
Yeah,
sir.
please. So, see, first, like I said, why IBC matters. See, before 2016, there were 4-5 laws which were governing the resolution process. I would say that which were governing because the IBC came into the picture for recovery of debts of banks primarily, and the resolution of the companies. Prior to that, there were 3-4 acts. One would be your SICA, that is your Sikh Industrial Companies Act. There was the Provincial Insolvency Act. There was the Presidency Towns Insolvency Act. Then there was SARFAESI. There was Recovery of Debt and Financial Institution Act 1993. Despite all these acts, the recovery ratio for banks and the creditors was approximately in the range of 10 to 15%. And once the companies used to take this route, either DRT or SICA or SIC tribunal, if you see the data, you will find that hardly any company came through, creditors hardly got any money. So the idea was to have a regime which consolidated all the provisions so that a the legislature wanted a resolution. They wanted maximization of assets for the creditors and so that the company can be revived. This was the intention, and that is why IBC came. And one of the things, if you see on the slide, which I mentioned, is dirty dozen companies. And this is interesting. This is why primarily the government had to, I would say, was forced to bring this because in 2017 there were 12 companies who had a consolidated debt of more than 2 lakh crores. Just to give you a context so that you can just sink in that at that point of time, if we compare the dollar, the debt was more than GDP of 70 countries. That was the debt India was facing, and this was only 12 companies. What has happened after IBC has come in? Out of 2 lakh 50,000 crores something of debt, approximately 1 lakh 38,732 has been recovered, and that is approximately 56% of the debt owed by these companies. So this is what IBC brought the change. It certainly brought the efficiency, expedited the process. The creditors were able to recover their money. Now we now go into what's new in IBC, and every new change which has been proposed by the bill or the recommendations of the select committee which have just come out in December, you will find that there is a history to it. So I will touch a bit of it so that you get a context of it. If you see in the bill, they have said that once you file the application, the has to mandatorily admit the application. And why they have said this? This is in context of Section 7. So just to give a background that in IBC, there is one application filed under Section 7, which is filed by the financial creditors. Section 9 application means the application filed by operational creditors. And Section 10 is the application filed by the corporate debtor itself. So what happened was that in Vidarbha, it's a Supreme Court judgment. The Supreme Court in one exceptional case said that the Section 7, which says that if there is a debt and default, the court can still see whether there is a default or a debt, and maybe what are the reasons for that default. Although later onwards, the Supreme Court said that this was an exception, it's not a law, but still, you know how lawyers are genius. They used to take this argument that even for admitting Section 7, that it should be read as a maybe, not a shall. So the government has clarified that the moment an application is filed, there is a debt and a default is established, then all the procedural requirements of the section are complied with, and the AA has no discretion left and it has to admit the application. The second part, which is unfortunate for me and it's going to be unfortunate for most of the people, is withdrawal restriction. And why I say so? See, the idea of IBC was that asset maximization, value maximization, and resolution of a company which is facing cash crunch. But over the years, what transpired was that operational creditors who had debt more than 1 CR started approaching the NCLT, filing cases against the corporate debtors, pressurizing them, and recovering their money. Now, if you see the data, you will find that over 60% cases were being withdrawn even before the stage of hearing by the NCLT as settlement. And this was a weapon for all the lawyers. So now what used to transpire was that although the court said that IBC is not a recovery mechanism, but practically what was happening was whenever a client used to come, the first advice for recovery was take a chance before IBC. Even knowing that it's not the right forum for recovery, take a chance before IBC before filing a recovery suit, because assuming you can establish that the debt is not disputed, you can easily pressurize the other party to arrive at a settlement. And that is what was practically happening. And to curb that, and what was happening because of that was the burden of NCLT increased a lot. The genuine applications of bank, the Section 7 application, the Section 10 applications, the other powers of NCLT, they have no time to hear the other applications. So to restrict that, to curb that practice, now they have made an amendment that once the application is admitted, it can only be withdrawn once the COC is constituted and approval of 90% of COC. Right now, the position is that even if the application is admitted, before the constitution of the COC, I can withdraw it by filing a Form 12A, that is taking the permission of the resolution professional, and inter se can settle the disputes. One challenge which other people were facing is assuming I go and I file the case. The COC is not constituted, but I see the public announcement. My claim is 2 CR. Other bank comes, the other bank is also knows that the company doesn't has money, and they are also trying to recover their money. So, but I have the first mover advantage. I go, I file the case, and that corporate debtor settles with me, pays me the 2 CR. Now, if I am an operational creditor, if this process goes through under the mechanism provided under the IBC itself, I am I am based at a very lower side. I would say that I am placed at fifth or sixth. The first priority goes to the financial creditors. Now imagine a situation where I have filed the case, I get the money, and the bank is left standing, no money, because I entered into a settlement. So the idea was to curb this practice so that there is no settlement once the application is admitted, and it can only be withdrawn post the approval of COC. Third is interim resolution professional. Now, this is a practical angle to it. Whenever a corporate debtor used to file the application under Section 10, and this is, you can say, what society we govern and we work in, this is the result of that. The corporate debtor used to appoint a resolution professional which they know or had good relations with. And what and once the application is admitted, the resolution professional plays a pivotal role in saying how the insolvency process will follow. Imagine if your resolution professional is your friend or in your control. You can certainly derive some benefits. You can delay the process. You can deny legitimate claims of the creditors. Realizing the practical situation, the government has now brought in an amendment that the corporate debtors can no longer nominate the IRP, which I also believe is a very good development. The other aspect is that they have increased the time period of the suspect transactions. Now, under the IBC right now, if the resolution professional finds that they are having some suspect transaction, they can certainly move an application. But the time period was till the time when the application was admitted. So supposedly I filed the application in 2024. It is finally admitted in 2025. The resolution professional could only go back till 2025. And what used to happen was that between 24 to 25, people used to get into shady deals or used to enter into transactions where they used to show loan to their known people or sister company or subsidiaries, so that whenever the IBC process used to kick in, they used to be the first creditors. Realizing the situation, now they have said that if the day application is filed, the resolution professional can go to that date. And I, in my view, this is also a very good development. It will certainly curb the ill practice which the companies used to adopt to defeat the legitimate claims of all the creditors by entering into sham transactions. The other aspect is the two-stage approval process. This is going to be a challenge in implementation. I don't know how they will implement it. So right now, what happens is that once the resolution plan is approved by the COC, it goes to the that is your NCLT adjudicating authority for final approval. Till the time the approval is not given, the company is not transferred to the SRA, which is your successful resolution applicant, despite being given go ahead by the COC. Now, this was creating a lot of challenge. What happens is a COC says that this plan is approved, that plan ultimately goes to the NCLT, and all kind of objections were being directly being given to NCLT, and NCLT could not decide on the approval application itself. And you will find, if you see, one of the reasons for delay is this, that NCLT only used to take 2 years to approve the plan which was approved by COC, because many creditors, the people agreed by it, the even the erstwhile promoter director, to defeat the interest of the SRA, to delay the proceedings, used to take all kind of objections. Now, to curb that, one suggestion has been made that it will be a two-stage approval process. One would be that the moment the plan is approved by COC, the successful resolution applicant will take over the control of the company, will try to revive it as per the plan, will infuse amount, and all the objections will be taken later by the NCLT qua the efficiency of the plan. I don't know practically how it will be implemented, because one scenario, if I see that the plan does not fulfill the conditions as given under the Act, assuming COC approves it, one party being the successful resolution applicant infuses the amount, and then in the future, 2 months down the line, 3 months down the line, the A comes to a conclusion that the plan is not as per the Act and the regulations. What remedy the SRA would have? How would he take out the money already infused? So that will, we have to see how they are going to frame this. But it is certainly a good development depending how it is implemented. Then the one thing they have done is that they have also extended the moratorium provision to liquidation. Now the present situation is that once the application is admitted, the IBC imposes moratorium. And just to give a background, the moratorium is that during the resolution process, no one can sell the asset of the company. No one can sell anything which is essential for running the company during that entire insolvency process. But assuming the resolution process fails, there is, you can't revive the company, there is no plan, and the company goes into liquidation, this protection used to go. Then all the creditors used to then again fight their cases in court to get the property. And what was happening was that the asset value was decreasing, because the moment moratorium went, the cases revived. They used to get the property, do everything, try everything to get their money. So now what they are doing is that they have said that for liquidation also, we are going to extend the moratorium. Third development is restoration from liquidation. Now that's a very interesting concept, that assuming that A, they don't find any successful resolution plan and the company goes in liquidation. As an exception, that during liquidation, assuming they find one property, one asset which no one was buying, now liquidation, during liquidation, that asset is now clean, and they feel that the company can be revived because of this asset, they have been given an option, although it says exceptional cases, but the option is there that from liquidation, the company can be again sent to CIRP. Now, the only practical challenge which I see for such kind of power is that certainly people are going to delay the proceedings by saying that you please send the company to CIRP even if it goes into liquidation. And that is how the proceedings are going to get delayed. That's my opinion, but let's see how it goes. And lastly is that they are balanced efficiency and fairness in the sense that they have clarified that security interest, because if there was one judgment of Supreme Court, Rainbow Papers, which created a lot of problem for everyone, it said that the government dues, if a right interest has been created, it is at par with the secured creditors. And right now, if you see Section 53 of the IBC, there is a waterfall mechanism which lays out what creditor is has the priority for the recovery of money. And the government dues, if you see, fall under the category of fourth or fifth priority. But Rainbow paper said that if a security interest has been created, and just to give you an example how it is created, assuming there is a tax demand. Basis that tax demand, the collector has started the proceedings for recovery of that tax demand from the company and created a charge on the property. The court said that in these kind of cases where a charge has been created, they will be, the government dues will fall under the category of secured creditors. And this judgment was discussed in many circles in IBC, and it basically defeated the intention of the government and the IBC legislature, wherein by this judgment the government dues became at par with the financial creditors. So this clarification by this amendment has come that security interest of the government dues will not be at par with the financial creditors and the secured creditors. They will be at the same position as given into the waterfall mechanism. And the second change they have brought in is that they have brought all the, either the IRP, the IBBI agencies, IP agencies, the registered valuers under the stakeholder protection. See what's happening right now. If you see and if you go through cases also, there have been many instances where the resolution professional or the registered valuers have tried to play smart with the court. They have been unfortunately in connivance with the SRP or the erstwhile promoters, where they have tried to lower the value of the company or try to sell it at a lower cost. But so, although IVB has a direct control over them, but it parallelly creates a lot of problem. So the amendment proposes that all these people will be under the domain of IBC, so that a balance can be created. One of the, and why these next two three slides find specific mention is, so the one of the processes which has been proposed by the new act is creditor initiated process. This is creditor initiated insolvency resolution process. So what it has done, see, in the cases of MSME right now also there is a provision of pre-packed insolvency resolution process. Now if you see in most of the companies India has, they are promoter driven company. In a promoter driven small company like a MSME, which is your micro, small, medium enterprise, you will hardly find professional people. I would say that like CXO, CEO, who know the running of the company. So there is one person that is the promoter who would have help of 5 6 people team who would control all the documentation, who would know what are the processes, how it is run, and in the end, the promoter word would prevail overall. So there is a practical challenge. How will you revive a MSME? The pre-package insolvency, which was a very good move by the government during the present regime, but it is not bringing out fruitful result because in the end, when a IRP enters, from whom they were going to ask for the documentation, from whom they are going to ask for clarity. It is only the promoter. And if the promoter is not willing to give that clarity, from where they will procure the documentation because of lack of processes. So the government has introduced a very, I would say that this is going to be one of the big game changers, that this is a creditor-led resolution process. So what they are proposing is that if 51% of the creditors, so they will define what kind of creditors will fall under this class, feel that this company has to be revived or there has to be an insolvency resolution has to be filed. So instead of moving an application to the court, they will themselves decide that this is necessary. They will give notice to the CD that we are taking this decision, and if 51% approve, it is bound over this corporator. But the best part is, in this, the control will remain with the corporator. So even the corporator, the promoter knows that even if the process is going on, I am responsible for running the company. Unlike right now, where the control goes to the resolution professional, they have set a 150-day deadline. They have also created guards. So once the creators interested decide how to take it forward, they will simply file that plan to the NCLT and seek approval. The other initiative is the group insolvency. This was much required, although this framework was proposed from time to time by NCLT and NCLAT through their various orders. See, if you see the insolvency of Supertech, if you see insolvency of Videocon, you will find a lot of practical problems were being faced by the NCLT. There were 10 group of companies. Just imagine that every group of company having a separate resolution professional, assuming for the time being that even they have one resolution professional. The practical challenge was that one case was being heard by one bench, the second case was being heard by second bench. So there was no consolidation. The dates, timeline, everything was going for a toss. So this time around with these amendments, they have put a dedicated provision which provides for a group insolvency. In this, as clearly given in the slide also, it certainly will lead to a better coordination, and it will allow the resolution professional, one resolution professional, to take over assets of all the group companies, so that the core of IBC can be realized, that is maximization and value of all the assets of the company. That is the core of IBC. The third major change which has been proposed is cross border insolvency. See, if you see the sections right now, I think it's section 237 to 40. It does provide for cross border insolvency. But the problem is this, that it provides that it is the order of R will be applicable to the countries where we enter into arrangement. To date, no such arrangement has been entered into by the central government. So even if I pass such an order, and assuming the company has one asset here, the company has another asset in USA, how will you recover that asset? If the company is going under insolvency, whether the USA court will recognize the orders of Indian court, and assuming USA court has first gone into bankruptcy, the company has filed it, whether the Indian courts will allow that company to go insolvency in India to recover the amount. So these were the challenges which were being faced by the government of India. They could not enter into arrangement with any kind of countries. So right now, if you see, they have said that yes, we will follow the unilateral model for insolvency, which is mostly recognized by everyone. But right now, only the Act only provides that they will frame rules. So till the time rules come out, it is very difficult to ascertain whether this is definitely going to help the government for recovery of dues, or it's just going to be a exercise which the government has done earlier, just rule on paper and not practical enough. So let's wait for the rules. Once the rules come out, then definitely it is going to give clarity on the issue. See, now if someone asks me why these changes are required, I would say that look, the IBC when came, is it a success? I would say by data, it suggests it is a success to some extent. But we have to realize that data is how you compare things. Before 2016, there was hardly any recovery by the banks. But post 2016, if you see the data, I think on an average, the recovery through IBC stands at approximately 38-40%, which is better than your SURFACE, better than your DRT. If I take average, to the best of my recollection, only in the year 2021, the recovery by SURFACE was more than IBC, the percentage. But it has created another problem. And that another problem is a very unique problem, that if the intention of IBC is to maximize the value of the company and maximize the and protect the interests of financial creditors so that they can recover the money to the best extent possible. If you see right now, the haircut which is being taken by operational creditors is 90%. So for every 100 rupees, I'm getting 10 as an operational creditor. For a financial creditor, that haircut stands approximately at 32 or 38%. I think is anywhere between 32 to 38%. So that's the recovery rate. So for 100 rupees being owed by the company, the creditors are only able to recover 32 rupees. Whether that is a success, I would say no, because the idea when the act came in, at least the impression was that the recovery is going to be far higher. What led to this delay is that a how the NCLT is functioning, and this is a practical insight which you will also learn when you are in this profession, is the delay. So one of the recommendations by the standing committee is also that if a appeal is filed in NCLAT, it has to be disclosed within 3 months. And I can tell you that this is a recommendation. How far it can be followed and how practical it is another aspect. From my limited experience in this field, I can say that at least there are 3-4 appeals by financial creditors with amounts more than 2,000 CR which are being pending in NCLAT for the past 2 to 3 years. So just imagine, by the time the creditor really gets the money, the asset is gone. And if the asset is like this, which is going to degenerate in value, and after 3 years, what money any creditor is going to get from it? So now one of the objectives with these amendments or the intention is that at least we can expedite the process. And that is what is your strengthening creditor rights and enhancing legal efficiency. And see, one of the things they have also done is that they have said, at least they have made it clear right now, that even the dissenting financial creditors, assuming I don't agree with the plan which is being approved by the majority of the COC. I may choose not to agree. I don't like. So what was happening was that the amount they were getting in some cases was not at par of what they would have gotten had they agreed for that. So now, inter say the Supreme Court stepped in and said, no, you have to give their right. At least it should match the liquidation value or the maximum value they could have got had they given the approval to the plan. Now, what they have done is they have incorporated the said provision under the Act also. So, this is, if I say that this is the overhaul of the new developments which has come into IBC. Now, I open the floor to any questions you want from me. Thank you.
Thank you so much, sir, for such an insightful and engaging session. We're really grateful for your time and for sharing your experience. We will now move to the question and answer session. Participants are requested to post their questions in the chat box. We will take as many questions as time permits. So, with your permission, we shall begin with the questions from the participants.
Yeah, please.
Yes, sir. Question by Goluji. Does the limited scope of judicial review under IBC adequately safeguard minority creditors?
I would say that on papers it does, but practically it is difficult because see the decisions are taken by majority. For every decision, my stake is determined by what debt is owed to me by the corporate debtor. And if I my debt is more, my percentage, my influence in the COC is going to be more. I need that 66% magic number. So if my debt is assuming that the debt owed by the company is 100, and out of that my debt individually is 67. So I already have more than 66% to do whatever I want to. The RP will be under my control because all the decision being taken by COC RP only I can approve with my only my voting. If I am not happy with any decision, assuming they say no, we will distribute the money and we will give some money to 33% people, I can say no, I don't agree to it because my vote is 67%. So, yes, to some extent, practically speaking, they do get affected because of the imbalance of power. The magic figure is 66%. If my debt is so much that I can reach that figure, or I can, with cooperation with some other creator, can achieve that figure, I can certainly influence the process, the outcome of the process, because I am the one who is going to decide which plan is going to be approved. Even if the other creators want that plan to approve and I don't want that plan to be approved, I can simply abstain from voting and the plan won't go through.
Thank you, sir. So, the other question by Harshit Pandey. How should conflicts between IBC and sector specific regulators like RBI, SEBI, PML be harmoniously resolved?
See, for co-op PMLA, I can say that a effort has been made. There is a specific amendment now. There is a clarification also that if the company is going moratorium and the under PMLA also the property is being attached, if the proceedings are pending, then certainly with the permission of PMLA, you can release the property to the SRA. But they have said that you have to see that though the interest, the money which has come from those properties should go to the original people. So that clarification they have given. And 32 also gives a clean slate that now once the plan is approved, then all the previous debts go. So they are trying to bring in a balance, but see, it's not a clear cut formula because the authorities they do act independently. RBI assuming you need a permission for a foreign transaction from RBI and there was a violation, can you today say no because I have? That's the idea. The idea is this only, that if the plan is revived, there is a new company, all the debts go. But it is very difficult for RBI to say that no, I will let that go, assuming the successful resolution professional is getting the money abroad from abroad. Then also they need approval. They need approval of the CCA also for mergers. So all this is happening right now. These are all developing questions. But the new amendments don't touch on these, but have not given clarity to it. I think this clarity will come through judicial pronouncements. Practically speaking, it's happening. On ground, NCLATs are taking this. They are giving, their intention is to, if the plan is approved by COC, if the plan is approved by the AA, most likely that plan is going to go through until and unless you will find some discrepancy which is totally against the law.
Yes, sir. Another question. How effective is Section 29A in preventing backdoor entry and has it discouraged genuine resolution applicants?
How successful? I can't say. Practically speaking, I would say, see, on papers it is successful, but see, you can't stop a person who wants to have intentions otherwise, right? So the idea is that it clearly says that a who are ineligible persons to give a resolution plan, but on ground there has been instances, or there have been at least arguments, or day in day out when I appear in NCLAT, you come across cases where the person is related directly or indirectly, even if they are not falling directly under Section 29A, you will find that there is some indirect connection. And the idea is, see, if I give a plan indirectly, which is going to be considered tomorrow, and I am in hands in glove with the promoters, what do you think I will do? And this is what practically people are doing to get in control of the company at a lower cost. It's the best practice you could do. You owe money to the banks. Indirectly you can control the company by giving just 20-30% to the bank and still have control of the company. That's the best thing you can do. Get away with the money. And that's what everyone tries to do. Take the money and go. So if you can manage that, and people are doing that, whether you are caught, the day you are caught, then of course you will find those orders in NCLAT and Supreme Court also. But these kind of arrangements, I would say, they are structured in such a intelligent way that they rarely come out, because these are being structured by lawyers with 10 layers and understanding how to protect people. There may be 10 shareholding. It's very difficult to find out the ultimate beneficiary if the person really wants to.
So, next question. Does the commercial wisdom of the Committee of Creditors undermine judicial scrutiny under the IBC framework?
No, see, COC, although the courts have, I think every other day you will find a judgment where the court say the commercial wisdom of COC is to be upheld. But the judicial scrutiny they have said is under the ambit given under Section 61, that is the appeal 60. Those contours have to be followed, right? So if some regulation is not followed by the committee under 31, regulation 31, and if A feels that this has to be followed, then certainly they will step in. But they will not go into nitty gritties of one creator got 10, one creator got 8, until and unless it is something which is given in the regulation. Like for the dissenting financial creators, it is given that the dissenting financial creator will get the value had the CD gone for liquidation, the liquidation value, not less than liquidation value. Assuming in the plan they find that the liquidation value would have been this, because the registered valuer actually gives that this is going to be the liquidation value of the company, but the money which I'm getting under the plan is less. Certainly I can challenge that, and in that case the A is bound to interfere. But they are not going to go into this question that why the other plan was not followed,
why this plan is better. Assuming my plan was rejected, I file a appeal before the A that my plan is being rejected. You hardly you will find cases where, until unless there is some violation of principle of natural justice, assuming I gave the plan, they did not consider it. I am taking all these circumstances out, but if the COC gave its mind to both the plans, all the plans, and decided that yes, this plan is better than the other, the COC wisdom is going to prevail before NCLT and the authority, and they are going to approve the plan. They are not going to interfere until and unless they find that some illegality has crept into the plan.
Thank you, sir. Next question. How does the Indian IBC compare with insolvency frameworks in the UK or the US?
See, to be very fair, I have not studied the insolvency framework of UK and US much, but what I know is that they are more faster. And see, from Indian context, you have to realize that once the company goes into insolvency, the first thing which everyone thinks is that they must have taken some money. At least for it's possible that even if I have taken loan, the company can fail. But here the first thing which comes into the mind of everyone is that something wrong must have been done. That is why the company failed. Maybe the business failed. Maybe the business changed. Maybe new regulation came. So there are so many companies which have. Take the example of online gambling, which was legal. One day the act came, it became illegal. Now, assuming one of those companies go into resolution, whether the intention would be that A, they must have done something wrong, or business failed. That's how the world works. We are in a capitalist economy, business do fail. I would say that US and UK economies are much mature. They do factor this that they are going to fail. So instead of fighting that who has done something wrong, they don't go into those exercise much. And their idea is to A, get the maximum money so that the creditors can be paid. And the one thing is for sure that the process is way faster. That I can say. Although on papers, Indian process is one of the fastest, but practically it's not happening because it's their own data that on an average is taking 600 days and the timeline is 180 days. So 600 days to get the resolution going through.
Thank you, sir. Last question. Have recent amendments to the IBC improved its effectiveness?
See, this is a premature question. They have not come into effect right now. The moment they are, see, it will take some time, right? Because the amendments were proposed, the scrutiny committee has given their finding on it. Once they come into the picture, once everything is taken care of, I think the impact of these will certainly be coming in another 6 7 months. But there are certainly two three interesting concepts which I also shared. But I'm looking forward to seeing a what happens with the recovery mechanism. Trust me that including me, most of the people are filing cases for operational creditors to get recovery of money, which we also know is not the intention. But it really helps, right? If you tell the client that you can get the money out within 1 year or 2 years and take a chance, instead of filing a recovery suit, which is going to take time. So everyone used to take chance before IBC. Now they won't because now you would need a permission from 90% of COC for withdrawal. So that will kind of uh, curb this practice, and I believe that the NCLT would have more time on their hands to deal with genuine applications.
Thank you so much, sir, for such an insightful and engaging session. We are grateful for your time and sharing your experience and expertise with us. We request the participants to fill the feedback form to mark your attendance.
Thank you everyone. Thank you so much. Thank you so much.
Thank you so much, sir.
Thank you,
Thank you
sir.
so much.
Thank you, sir. If the feedback form is filled, participants can leave the meeting. For the ones who is not able to access it, kindly try it again. Thank you, participants. We are now ending the meeting.